Had a very chilly Beltway this morning. Good morning to you. Hope your Christmas shopping is underway. I want to begin by thanking Dwayne, who sat in for me on Monday, Kurt Schlichter, who was here on Tuesday, and the wonderful Mark Davis, who was here on Wednesday. The three caballeros did a wonderful job as I filled in for our injured colleague and friend, Dennis Prager, on the first leg of a cruise he always takes with his listeners, some of whom are Hugh Hewitt listeners, some of whom are not. Mike Gallagher flew in and took tag team. If you ever used to watch tag team wrestling, gave me the tag, jumped on the boat. I got off the boat and came back to D.C. because there's too much going on to skip a whole week of radio. Best wishes continue to flow in for Dennis. I don't have any updates for you. Watch the Dennis Prager channel for updates. And if you want to send him good wishes, there is a button at hughhewitt.com. He is having those transmitted to him. They're all collected by Salem, and they get over there. And he does appreciate them. So thank you. I want to begin by saying I spent most of my time when I wasn't lecturing or eating in the room working on my syllabi for classes I teach beginning in January. I teach constitutional law, and then I teach First Amendment, 14th Amendment, as I have since 1996. But it's a radical new approach. I'm doing it completely differently than I have ever done it before because the court is different. The majority has now been there long enough. The originalist majority has been in place since the confirmation of Justice Barrett, and Justice Brown Jackson's replacement of Stephen Breyer didn't change much. It's a 6-3 court on most questions that divide the court, and most questions don't divide the court. But yesterday was a perfect example of why I had to redo everything. The new originalism, as opposed to the old originalism, as opposed to the old living constitution. There are really three schools of con law. Living constitutionalism. Here's a suggestion in the Constitution. Let's run with that. And that held sway until the early Roberts Court. Occasionally, Chief Justice Rehnquist would take a whack at, say, the expansiveness of the 10th Amendment versus the Interstate Commerce Clause, but it didn't work. It took numbers. And the numbers began to arrive with Justices Alito, Thomas, and Chief Justice Roberts being assisted by the arrival of Justice Gorsuch, Justice Kavanaugh, and Justice Barrett. So there are now 6 originalist justices. It doesn't tell you how a case is going to come out in most cases. But yesterday, if you followed any bit of cable news, and I confess, I do not watch cable news except for special report and occasionally a special breaking story. I will go and see if something is going on. I like to watch the snow pile up in Ohio, although that's not breaking news. Lake effect snow is not breaking news in Buffalo or Ohio, but I like to watch it because I grew up with it. Nevertheless, yesterday's coverage of the court hearing on the Tennessee statute, which has been upheld by the Sixth Circuit, and I have the Sixth Circuit opinion right here, penned by Judge Sutton, saying, life tenured federal judges should be wary of removing a vexing and novel topic of medical debate from the ebbs and flows of democracy by construing a largely unamendable constitution to occupy the field. Well said, Judge Sutton. I never thought this was a closed case. I don't think it is a closed case. I believe the justices will uphold the Tennessee statute and do so in rather rapid fashion in a cursory opinion. I expect the Chief Justice to author it, to assign it to himself. He said at the hearing yesterday, quote, "The Constitution leaves the questions to the people's representatives rather than to 9 people, none of whom is a doctor." Now, the more entertaining quotes come from Justice Alito, who had a little fun legislative debate with the Solicitor General and the counsel from Tennessee and the ACLU. And so it was kind of fun to listen to. But that was a legislative debate. The Constitution is absolutely silent on medical treatment of children who are experiencing gender fluidity. And I do want to let parents know, if you're driving to school and you got kids in the back seat, if they're not the appropriate age, you really don't want them to hear what follows. But I do want to go back and point out that Chief Justice Marshall, it's 200 years ago, in a case called Barron v. Baltimore. I love to teach Barron v. Baltimore. Baltimore had messed with this guy's pier, had flooded it, had destroyed it. And he sued them under the Fifth Amendment. This is before the 14th Amendment, right? So there's no Civil War yet. There's no incorporation of the Bill of Rights yet. The Bill of Rights apply to the federal government. They don't apply to the state government before the 14th Amendment. This is a long time ago, but Chief Justice Marshall, one of my favorite quotes in all of constitutional law, said that the question then before the court was, quote, of great importance, but not much difficulty. And that's his way of saying, and I expect Chief Justice Roberts to cite him if he assigned him the opinion. The Tennessee statute was passed by the Tennessee legislature to deal with Tennessee children. There's nothing in the Constitution about medical standards and how they have to be applied to any group of people, minors or adults, on any subject, whether it is kidney transplants, heart transplants, gender transition surgery. It is not a question for the Constitution. It ain't in there. It's not there, just like abortion. This court just did all the heavy lifting on Dobbs to return the constitutional system to its proper balance, which is, hey, state legislatures, you do your job, we'll do our job. If you pass a law shutting down a newspaper, we will reverse you because that's contra the First Amendment. If you pass a law restricting the right of someone to own and possess a firearm in their house, we will reverse you. But generally, the police power belongs, and that is the power to regulate medicine, to the state legislatures and the state Supreme Courts and how they develop. And there are 50 different rules. And it's not a hard case. The idea that it's a hard case, it's going to be a blowout case. It's going to be at least 6-0. It ought to be 9-0. It ought to be about 2 paragraphs long, and the court ought to get back to short opinions. And I realize it's a question of great interest to a small segment of the media and a smaller segment of trans activists. It is not a difficult constitutional question. End of story. Second question, can Joe Biden pardon his son for 14 years worth of things? Yes. Yes, he can. He did. You have to ask yourself, why did he do that? And the answer is because Hunter Biden has been breaking the law for a long time. But I also got, and I must tell you, it's lovely to read, the opinion of Judge Scarsy in the Central District of California, where he just slams Joe Biden. And he slams Hunter Biden and Hunter Biden's legal team for sending him a press release as opposed to the appropriate paper seeking dismissal. He ordered dismissal, but not before he said a few things about the president's pardon. First of all, he said it lies about the fact that Hunter Biden's addiction was responsible for his tax evasion. It wasn't. He was sober when he refused to pay his taxes. He didn't have the money. And Judge Scarsy notes that 2 federal judges expressly rejected Hunter Biden's arguments that the government prosecuted Hunter Biden because of his familiar relationship to the president. In short, a press release is not a pardon, Judge Scarsy writes. The Constitution provides the president with broad authority to grant reprieves and pardons for offenses against the United States, but nowhere does the Constitution give the president the authority to rewrite history. Boom! And I love the brevity. Judge Scarsy is, I have met him a few times. He's not a friend. I wouldn't call him a friend, but he's a very smart, big firm, big law guy from L.A. And he's just looking at this and said, this is absurd. This is the attempt by the president to rewrite history. It's his Department of Justice. It's his son. It's tax evasion. It's lying on a gun registration form. And we aren't having selective prosecution here. And you've got the power, Mr. President, to do this. But it's interesting. If you read the actual underlying document, you realize they're having meetings in the White House about issuing preemptive pardons. Those don't exist. The existing guidelines, as Judge Scarsy reviews, provides that, according to past Supreme Court precedent, a president can pardon for infractions against the United States, crimes against the United States that have already occurred. So you can do a blanket pardon backwards. You cannot do a pardon going forward. What is most interesting about the pardon of Hunter Biden is it means he can be summoned to any committee of Congress and he has no immunity. So he's got to answer the questions. If he refuses to, he's in contempt. He can be jailed. He can be, by the way, brought before any grand jury investigating Foreign Agent Registration Act violations by his uncle, by his other family members, by his business partners, and he cannot plead the Fifth Amendment. So we're going to be seeing a lot of Hunter Biden in the weeks, months, and years ahead, unless we get a whole bunch of pardons. Unless the world is full of pardons at Christmas, like snow at George Bailey's Bridge. Who knows? Maybe whenever Joe Biden issues a pardon, an angel gets it.